Welcome everyone to the fourth podcast based on the book Anarchy and the Law. This will be the last podcast that we'll do on theory. After this, we'll move to part two of the book, which is the debate between anarchists and minarchists. Technically, there's only one chapter left in part one, but we have to cover, that we have to cover in this session. But I've added a couple of more chapters in this section, which I think must be read with the myth of the rule of law. First is the Hierarchy and Anarchism, which is written by the same author who compiled this book, Dr. Stringham. And second is Justice Entrepreneurship in a Free Market, which is a little advanced for beginners, but I think it has some good insights from Kerzner's contribution to Austrian economics. And I think they answer a lot of questions which much better. Now, Hayek was no anarchist. He remained a liberal until the very end. But some of his works on common law indicate certain applications of his thought that we can use to predict and explain how law could, and in some historical cases, it has come about to be. Hayekian understanding of markets is that it is a process of discovery or learning. What that means is that we live in a world of ever-changing information. Some resources are found here and some demands of the people change over there, and economy is a dynamic entity. It keeps on constantly changing. We don't have the complete knowledge of the market, the demand of goods and the supply of resources, etc. As a discovery process, what is meant is that even though the economy is dynamic, the market process of pricing allows for the spread of information in a decentralized manner. This process works on the principle of profits and losses, which provide constant feedback to help producers see if what they are producing is of any value to the consumers. Not just that, competition itself is a market process that acts as a test to discover what arrangement and management of resources produce what is best for the consumers. If we knew beforehand, we would need no competition. If we knew what is best for the consumer, we would simply implement it. Prices are also signals on the market. Profits attract other entrepreneurs and investors into certain industry to get a chunk of those profits. This way, by enticing entrepreneurs with profits, the market works to pull investments into the most urgent needs of the consumers. So that market works in accordance to what the consumers want. Market process allows for coordination of various people with different goals to work towards producing basically what consumers want. Of course, nobody knows for sure what he wants. All entrepreneurs make educated and calculated estimates of what the final picture may look like when their investments have come through. If they estimate it better, they are rewarded for it. If they estimate it poorly, they are punished with losses. An entrepreneur needs to be attentive. He needs to be on the lookout for opportunities and knowledge to improve his estimate and thereby increase his profits. Hayek considered this to be spontaneous order. In this understanding, a vendor is not setting the price of a good, but discovering it. Of course, he's setting it. Ultimately, it is his decision, but why is he setting it to some certain value and why not some other value? The vendor uses the market feedback mechanism to discover the price that best reflects the supply and demand of that good. However, if he doesn't do that or does that poorly, in retrospect, of course, he makes losses. Vendors who make losses go out of business. Those who remain in the business are the ones who have discovered the price correctly. People usually say that we need someone in the center of the state who is strong and knows what needs to be done. But the reverse is actually true, because no central organization could gather all the information necessary to form a plan, it becomes an activity that lacks the test of market. A system of central planning is without a rudder. Hayek applied the same logic to law. In his initial writings, he was a supporter of state-based law, formal legal rules clearly expressed, prospectively promulgated, and equally applied. That is the concept of rule of law. But he shifted his stance later on towards what was called common law, originating from England. He saw that system of law to be more bottom-up and more efficient in dispersing knowledge than top-down legislature-focused approach. English common law had some elements of libertarianism. In particular, there were competing courts that handled dispute resolution. Some courts still functioned with authority, and of course, the monarchs gradually took over the system. But we can understand how competing courts could function by looking at that era. The reason it was called common law was that despite there being a competition between courts, they arrived at a certain understanding of the law, which was common among the courts. This isn't cartelization, but rather aggregation. If a particular court is too lenient on pickpockets, other courts will be stricter and attract more cases. Similarly, if a particular court is too strict on pickpockets, the thief would appeal to a court that was slightly more lenient. Gradually, the courts therefore came to an understanding that what the law should be and what should be the punishment for breaking that law. In a pricing mechanism, if you look at the big picture, you can see that the vendor is not setting the price, but more like trying to discover them. Similarly, in the common law system, the judges are not writing the law, but rather trying to discover the laws that minimize the conflict in a given society. When they arbitrate and settle conflicts, they are discovering what is acceptable to the participants and onlookers. These patterns of arbitration are then codified and written down. But they are not laws in the way we understand laws to be. Judges are not bound by them, but rather they use them as a reference, just like how entrepreneurs use the going market price as a reference. Judges in such a system are not creating or imposing the law. If the going rate of potatoes is rupees 10 per kg, it doesn't mean that there is a physical compulsion to sell at rupees 10 per kg. A vendor may sell it at a higher or lower price depending upon what he imagines the future to be. The feedback of profits and losses help him gauge whether his decision was right or wrong. Similar is the case of a judge in a common law. If his cases are constantly being appealed in other courts, people will stop coming to him for arbitration. They will go to the courts which have discovered the laws that are better suited to resolve conflicts. This way, the law gradually evolves to better represent the needs of the consumers of the law. Hayek also had a notion of what law is, which he got from David Hume. He considered that the essence of law is not created by the state, but pre-exists in the conventions and understandings of the individuals that compose a given society. This is complete reverse of the legal positivist jurisprudential school. Hayek writes, the basic source of social order, however, is not a deliberate decision to adopt certain common rules, but the existence among the people of certain opinions of what is right and wrong. Except where the political unit is created by conquest, people submit to the authority not to enable it to do what it likes, but because they trust somebody to act in conformity with certain common conceptions of what is just. There is not first a society which then gives itself rules, but it is common rules which weld dispersed bands into a society. With this understanding of the law has never been invented, nor can it be promulgated or announced beforehand. But the rule of law that exists today implies that it does. Surely the laws that are legislated into in our parliaments and they are indeed published by the government and applied equally to everyone. So either our conclusion is wrong or the rule of law is a myth. There is no alternative to reading the myth of the rule of law. It's a long paper written to break this myth, and it has many hypothetical and real examples. But let me try to quote some excerpts from it. I refer to the myth of the rule of law because, to the extent this phrase suggests a society in which all are governed by neutral rules that are objectively applied by judges, there is no such thing. As a myth, however, the concept of the rule of law is both powerful and dangerous. The its power derives from its great emotive appeal. The rule of law suggests an absence of arbitrariness, an absence of the worst abuses of tyranny. The image presented is one of fair and impartial rule rather than subjugation to human whim. This is an image that can command both the allegiance and affection of the citizenry. But this image is also the source of the myth's danger. For if citizens really believe that they are being governed by fair and impartial rules, and that the only alternative is subjugation to personal rule, they will be much more likely to support the state as it progressively curtails their freedom. People generally know that the legislative body is corrupt. They know that the laws they make are politically motivated. These laws are passed either for profits at another's expense or for special interest groups. People also know that each court case depends heavily on the judge and his ideology. A judge's job isn't mechanical. He has to make judgments not only based on the legislative law, but his own understanding and ideology of what is right and wrong. Within the activist circles, it's also widely known but rarely discussed that judges can be corrupt too. But even mentioning that is considered a taboo. But despite knowing all of this, people have no trouble believing the contrary, that we live under a system of law, which is a body of definite politically neutral rules amenable to an impartial application which all citizens have a moral obligation to obey. John Hasnas gives an example of how the legislative law is interpreted differently by an example. Just give me a minute. So he gives an example. A woman living in a rural setting becomes ill and calls her family physician, who is also the only doctor, for help. However, it is Wednesday, the doctor's day off, and because she has a golf date, she does not respond. The woman's condition worsens, and because there is no other physician around, she dies. Her estate then sues the doctor for not coming to her aid. Is the doctor liable? Now, if you're politically conservative, you would argue that a doctor deserves a day off and that without an explicit contract between the doctor and the patient, there is no grounds for liability. If there was no written law, this would have been your judgment. But under a written law, you need to find past cases and interpretation of law that helps your case. There have been past cases where the doctor has not been held responsible without a written contract. So your initial impression was correct. The doctor is not liable. However, if you are politically liberal, you would argue that when the doctors take the Hippocratic oath, they accept a special obligation to care for the sick, and if you let the doctor go without liability, you would be setting a bad example. The bad example that doctors can let people die if they are not under written contract. Without a legislated law, this would have been your judgment. But under a written law, you need to find past cases and interpretations of law that helps your case. And there have been past cases which establishes the rule that in the absence of an explicit contract, the law will imply a contractual relationship where such is necessary to avoid injustice. So your initial impression was correct. The doctor is liable. Observe carefully that both the liberal and the conservative are doing. They clearly have their own understanding of what is right and wrong, and they both are trying to influence judgment, much like our economic understanding of law predicted they would. But under a system of legislative law, they are clinging to aspects of law that helps their case. A good lawyer can find a logically sound argument for almost any legal conclusion. Because the legal world is comprised of contradictory rules, there will be sound legal arguments available for not only for hypothesis one is investigating, but for other competing hypotheses as well. When two people debate the interpretation of the law, they usually assume that their interpretation is correct and that the other person is playing politics with the law. The truth is both are playing politics. The law is never neutral or objective. This does not mean that all judgments are simply arbitrary or there is no pattern, but that the pattern is not in accordance to the demands of the consumers of the law. The observation that the legal system is not highly unpredictable is correct, but it is a mistake to believe that this is because law is determinate. The stability of the law derives not from any feature of the law itself, but from the overwhelming uniformity of ideological background among those empowered to make legal decisions. Because we do observe judges forming a pattern of interpretations, we see that interpretations of legislative laws evolve over time to something that might be contrary to the legislative intent of the law. And the case of clashes of interpret and in cases of clashes of interpretation, it ultimately comes down to the Supreme Court. But if that is so, can we still call it the rule of law and not of people? Now that we have concluded that law is never neutral and objective, can we still say that people with the authority to use law will forcefully use law to forcefully adjudicate and arbitrate are imposing the will of the law or their own will? But then we can make the rule of law. But can we make a rule of law society? Granted, we don't live in one, but is it possible to construct one or write a book of law that is final and objective? No, there is no such thing as an uninterpretable language. Language itself is part of the spontaneous order. It was not that someone wrote the rules of grammar and people started obeying the rules. It was that conventions started to be codified and written down that became grammar. It was usually written down by people who were best qualified to write, that is, writers and literary geniuses. Law written in language can itself never be objective. Different people reading it will interpret it differently, mostly influenced by their political opinions. But would you even want to do that? Can the legislators write down a dispute resolution for all possible scenarios that will take place in a society? If that were true, would we even need judges? If it was possible, really possible to have written down end results for all possible court cases, we wouldn't need judges. The enforcers, that is the police, would simply read the resolution and implement it. As long as law remains a state monopoly, as long as it is created and enforced exclusively through governmental bodies, it must remain indeterminate if it is to serve its purpose. Its indeterminacy gives the law its flexibility, and since as a monopoly product the law must be applied to all members of society in a one-size-fits-all manner, flexibility is its most essential feature. More definite and rigidly determined the rules of law become, the less the legal system is able to do justice to the individual. Continuing our analogy of the marketplace, it would be like asking if it is possible to set one neutral and final price of tomatoes that works for both buyers and sellers. Is it? It is not possible to do so. It is true that governments have tried to set price floors and ceilings, but it is also true that for the functioning of the market, there arose black and gray markets that bend and even break the rules so that consumers get what they need. Similarly, it is true that although the legislative body tries to impose a certain set of rules, but the lawyers and judges need the flexibility so that they are able to do any justice. Just like how government price fixing cannot estimate for various kinds of consumers in the situations, government law fixing cannot estimate for various kinds of citizens and situations. And finally, just like those with license to sell tomatoes exploit their power, so do those licensed to give out justice. That is, judges, police, and legislators. I'll take a break. And does anyone have a question?
Not me.
Okay, but what about the predictability of law? We just discussed that under the rule of law, the law is predictable because it is based on consensus between the judges. What about private law? Will a law be predictable under private law? Hayek saw this as a major weakness of private law. He writes, I believe there is one convincing argument why you can't leave even the law to voluntary evolution. The great society depends on your being able to expect that any stranger you encounter in a given territory will obey the same system of rules of law. Otherwise, you would be confined to people whom you know. And the conception of some of our modern anarchists that you can have one club which agrees to one law and another club which agrees to another law would make it just impossible to deal with any stranger. So in a sense, you have, at least for a given territory, a uniform law, and that can only exist if it is enforced by the government. To Hayek, the common law system appeared to be a good compromise between predictability and discoverability. Common law becomes more and more predictable as it accumulates more and more history. While legislative law appears to be more predictable, the common law provides greater predictability because its decisions derive from widely shared notions of what is just, making it easier for people to conform their behavior to the expectations of the law rather than having to seek technical legal advice to know whether a proposed action is permissible. The process under the common law system are also better suited for discovery because laws are being made by the judges on the job. No longer bound by the written law, the judges are free to discover laws that are best suited for dispute resolution. From the chapter, Hayek views governmental judge-made law as a proper scope for development and a crucial element for spontaneous order. Whereas the content of the law can arise spontaneously, the institutional infrastructure of courts cannot be left to the competition and spontaneous order process. But Hayek also grants that to the government another important power. He grants the legislator the ability to alter the law when common law reaches a dead end. To Hayek, it is the best of all worlds: reliance on individuals who use accumulated knowledge and operate within a greater framework to ensure that the market persists. Individual judges could rely on precedent in law and in much the same way that individual producers in the market rely on prices. But we aren't here to promote this thought, we are here to learn from it and build on it. The Hayekian reasons to choose common law over legislated law can be applied to conclude superiority of private law over common law. Even in the Hayekian type of common law, we can see that at the outset, even well-intentioned judges will have little idea if they are discovering laws that people support in society. Although his system contains one-to-one competition among judges, it lacks a feedback mechanism to signal whether the system as a whole is working out for the consumers. We discussed how, under legislated law, the judges come in consensus on the interpretation of the written law. So too will judges come in some sort of consensus in common law, but that consensus will not be economically influenced by the consumers. From the chapter, the real test of the usefulness of legal law is found in the unseen effects of the rule, in terms of the number of accidents avoided or conflicts averted, not the seen effects of the cases that come before the judge. On this question, the judge will have almost no relevant knowledge, or crucially, a way of possibly acquiring the relevant knowledge to make that assessment. With a monopoly and no feedback mechanism, how will the judges know initially, or as consumers demands change, whether a particular decision to or verbal articulation is consistent with the underlying expectations? Although knowledge of the past, as embodied in the process of precedent, may be superior to no body of knowledge at all, it seems inferior to knowledge of the past as well as present. If, on the other hand, the common law allows judges to overrule precedent, it does not indicate when or what the new decision should be, whether the court decides whether the court decides will be enforced, so how the right or wrong decision could even be compared is not clear. Lacking a feedback mechanism, the judge is on his own. Furthermore, the stakes are extremely high because if the judge chooses incorrectly, he could set off a chain reaction of unintended consequences. One has to ask, at what point do we determine that a precedent is wrong? Precedent is wrong. That is to say, at what point do we determine that the evolution of law has gone in the wrong direction? Without the feedback mechanism from the people, someone has to take an arbitrary decision without a feedback. Whether it is the Supreme Court, the legislative body, or even the voting public, nothing will compare to the feedback mechanism of market pricing. The second problem is that of accountability of judges. Hayek prescribes how the judges and the legislative body should act. However, it is the institutional arrangements that determine whether they will act in that manner. The knowledge problem deals with the well-intentioned judges. The accountability problem deals with a judge who doesn't want to be constrained. Judges can attempt to discover Hayek's preferred law of liberty, or they can pursue their own political agendas. We must acknowledge that as feeble as it may be, there is a reason why distribution of power exists among judiciary and legislature. Government judges maximize their utility just like everyone else, which can include increasing fame, leisure, money, specific political outcomes, or state power. No matter how strictly a set of laws are drafted or adherence to judicial precedents may be commanded, the rule of law will still have to be implemented, interpreted, and executed by human beings. Absent competition, there is no obvious constraints on judicial agency costs for judges to pursue their personal preferences rather than seeking to discover a law as Hayek says they should. Hayek proposed solution of granting to the legislator the power to control judges and improve the law merely shifts the problem one level higher. The problem now becomes one of controlling the actions of the legislature instead of the judges. And then to control the legislator, we end up with voting and democracy. Hayek's idea that judicial institutions must discover and implement laws of society rather than making those laws is a good idea. But the institutional structure that he proposes lacks the incentives and knowledge to do just that. We must have competition among different suppliers of law, and consumers must be allowed to choose among those suppliers. Only when the consumers have that choice can there be a feedback mechanism, without which we have problems of accountability and knowledge. A pricing mechanism would incentivize the judges to discover laws that best resolve disputes rather than pursue their own political ends. Judges that form laws acceptable by the public would attract more and more cases. In fact, of particular interest here is the legal system that Hayek holds up as the model for his ideal of law was the English common law system. But that system itself was characterized by multiple providers of legal services competing side by side for centuries, including multiple common law courts, church courts, and law merchant, and other private courts. Okay, so any question on the on this? I'll just take a break.
Hey,
Yeah, Shikhar asked the question.
yeah. In these competing courts setup, uh, there can be two kinds of cases. Obviously, like one is genuine intersection of interests, where neither of them is trying to overpower, and obviously the second one would be where either of the party at least is trying to overpower the other one. So, in genuine intersection of interests, we know that it would be the best interest of both parties to come to a resolution as quickly as possible. But in the cases where one party is deliberately trying to overpower the other one, why would the aggressor want to even come to a courthouse? Why would it be in one aggressor's best interest to take his thing to a court?
Okay, so uh, arbitration actually begins when two parties are ready to settle. That part is true. So what you're describing, that one particular aggressor will not ready to arbitrate or come to any sort of resolution, that could very well happen. Uh, and this would lie best in the realm of private security rather than private law. I mean, the actions of a private security agencies will still be judged by the private law, in the sense that a private agency will open up a court case in the law agency that has contracted, and that law agency will open up a trial, a public trial, and it will give an open invitation to the accused to come and defend himself. They will also offer all sorts of. We'll see later why they'll do that. I mean, the economic incentives to do that, but they'll offer him a defense attorney, and a fair trial, and all of those things will be offered. But even if he doesn't show up after all that, then the private security will be uh, the private law court will rule in favor of private security. He'll be tried in absentia, and the private security will simply take action. When there is obviously hostility, there can be no resolution, there can be no mediation, no arbitration, nothing is possible uh, without the state. Nothing can be done. If someone has really taken it upon himself to really fight everyone, or for some reason be an aggressor against or against be an incorrigible aggressor, then there's nothing that can be done. Okay, so let us now turn to our attention to the topic of justice entrepreneurship. Because market is not an automatic process. If it were, we would be in the system of free market in law. The degree of success of a marketplace depends on an entrepreneur. Just because there are profits to be made in that certain industry doesn't mean that the entrepreneurs will invest. There are various physical and ideological barriers that can stop an entrepreneur from investing in an industry of justice. Ideological barriers can be personal or even that of the consumers. If the consumers themselves hold a belief that proper law can be provided only through the coercive action of the state, uh, markets will simply step aside and let the state provide the law coercively, as what is happening. It is only when the individual actors start to realize the injustice of the system will there be any change in the market landscape. And this, I propose, is the function of discussing this topic. It is to break down those ideological barriers so that not only are the market solutions for justice become acceptable to the consumers, but the entrepreneurs start to think on how justice can be provided in a free market. But there are many aspects of entrepreneurship that will come into play in justice. We will discuss some of them because I think they answer a lot of questions. First, we must discuss why justice is an entrepreneurial role. We notice that in the private law system, there will be private responsibility for everyone involved. The person who files the case, the person who does the capturing if needed, the person who defends against the capturing if present, the prison guard, the prison house that imprisons, the guard that keeps a watch on prisoners, the arbitrator who resolves the dispute between two agencies. Everyone is privately responsible. If the police arrests you and imprisons you and then it is unable to prove your crime in the court of law, they are not treated as kidnappers or enslavers, even though what they did is exactly that. In the private law society, this is what your actions will be treated as if you fail to justify them. This brings the element of entrepreneurship, the factor of risk, that you may lose the case and hence have to pay a restitution to the victim whom you thought to be a criminal. One argument goes that we need a proper procedure in order to convict someone of a crime, and before doing that, there could be no use of force permitted. This is why we need the state to monopolize the law. But then the question becomes, what is the best procedure to follow? We can clearly see that no such objective procedure exists. The procedure itself has evolved over time. So we must instead focus on why such procedure evolved and whether markets have a mechanism for free evolution of such judicial procedures. There are two aspects involved in understanding why such judicial procedures exist, even under the state. One is the restitutive risk that we discussed, and the other is the presumption of invasion that we discussed a few podcasts ago. The libertarian theory of justice is primarily a matter of restitution, not of punishment in the conventional sense. But before restitution can be extracted, we must determine whether violation of rights occur. If you noticed that many libertarians have asked the question of well, when many libertarians are asked the question of whether something should be legal or illegal, they use the non-aggression principle to find an answer. But if you look at that question, you will realize that the guilt is assumed to have been established already. The justice system doesn't work that way. The accused doesn't automatically confess to the crime. There is a need for procedure to establish whether the accused has committed the crime or not. But why does an agency need to settle an issue of knowledge at all? It is usually accused that private defense agencies will simply be glorified mercenaries who will simply be act like a hired gun and commit acts of invasion without proper check. Indeed, a corrupted justice agency will simply be nothing more than a mercenary for hire. But so can the state actors be a mercenary for hire, and indeed, sometimes they are. What we must compare is whether there are risks involved in being corrupt under a private law society than under a state. This is where the discussion of procedures come in. An agency that does not follow a procedure that minimizes the risk at being labeled a rogue agency will be marked as an outlaw agency by the other competing agencies. Justice agencies under a private law system are more than just hired hands to catch criminals. And this has to do with the usual notion of why people don't take law into their own hands. Well, because it is risky. A justice agency assumes the burden of the risk that accompanies with the use or threat of physical force in a free society. A client contracts with a justice agency not only because the agency is more efficient in obtaining restitution, but also because the agency is more likely to overcome public suspicion that the force used to obtain restitution is of an invasive nature rather than restitutive nature. The degree to which an agency can minimize this risk is the measure of its reliability and ultimately the source of its profit. One of the risk factors is the presumption of invasion. We discussed this a few podcasts ago that if you see someone take a bike that someone else just parked, you will conclude that it is being stolen, even though it is completely possible that the person is reclaiming his stolen bike. This is called presumption of invasion. And statistically, when you see someone taking some property without consent, you assume that it is being stolen, not recovered. This is because of partial knowledge that the onlooker has. It could very well be that the onlooker intervenes himself or reports you to his own agency, even though the person knows for sure that the bike was his. There is always a risk of complicating the matter by taking it into his own hands talking to the without taking the onlookers into confidence. This is the risk originating from the presumption of invasion. But if we were to see someone dressed in a police uniform together with proper crane, with proper papers coming and claiming the bike, that risk is minimized. In that sense, in the case of the state, that risk is minimized too much because the people not only believe that proper procedures must have been followed, but that the law under which the bike is being confiscated is part of the rule of law. However, such risk can also be minimized by brand name and that advertises proper procedures. A man dressed in the justice agency's uniform with proper papers from parent company would also be trusted by the third party watching if he knows that this agency can be trusted with doing justice. Moreover, if the police is caught taking bribes unethically and they do that by the way to teach sorry let me repeat. Moreover, if the police is caught taking bikes unethically and they do that by the way to teach the lesson about leaving bikes on the street, they lose no reputation. No harassed customer can unsubscribe from this service or hire another service that could challenge this act. Whereas if a private agency takes a bike unethically and the public later finds out that it was actually stealing or harassing, not only do they lose customer, they also lose that public reputation as a justice agency. Next time they arrest someone or confiscate some property, they are more likely to be reported and intervened by other third parties. Justice entrepreneurs have incentives to discover procedures that minimize this risk of restitution, and that will be the part of the product that they are selling. If they act as hired mercenary for criminal purpose, they risk losing that reputation as a justice agency. For this same reason, even states do not offer their services for hire for criminal purposes when they first enact it as law, and then every policeman is legally bound to act as a mercenary. A person certainly has the right to recover his stolen property uh, and restitution, but the risk of doing so without taking others into confidence is unavoidable but minimizable through proper procedure. Just a break. I'm taking a break. Okay. Entrepreneurs exist on the market because of knowledge gap in the market. An entrepreneur is someone who was alert about an opportunity for profit. He sees a knowledge gap and he takes the risk of proving it. This was the additional insight given by Kersner, that not only is risk an aspect of entrepreneurship, it does not explain why that even though that not only is risk an aspect of entrepreneurship, it does not explain why some people take risks and some don't. It is because of alertness. While it is true that different people are risk takers to a different degree, it is also true that anyone who takes a risk blindly is making a huge mistake. Entrepreneurs do not take risks blindly. They are alert and therefore notice something that makes certain investments seem less risky. This entrepreneurial knowledge helps to reduce the absence of coordination. A similar knowledge gap exists between a victim taking his property back and the third party that is aware of the previous injustice. This knowledge gap will inevitably result in a violent clash, and it opens the door for profit to one who can successfully bridge this gap. A justice entrepreneur seeks to coordinate disparate bits of information and thereby harmonize the actions of different individuals who operate from different contexts of knowledge. The second aspect of entrepreneurship is risk and speculation, that is restitutive risk. An agency that acts without proof to recover some property that was reported stolen is taking a risky decision. If it is found later that the object was indeed not stolen, they become liable to pay restitution to the person they stole from. An act of recovery becomes an act of theft without proof to the contrary. But does that risk go away after an investigation? There have been countless cases of people being convicted and even hanged, only to be found innocent later on. So speculation never goes away. We have never heard that a person must be proven. We have always heard that a person must be proven guilty beyond reasonable doubt. But how much of doubt is reasonable? People who don't have people who don't have private responsibility for carrying out the punishment, do they even have proper incentives to decide what is reasonable? After all, it is speculation to say what is reasonable and what isn't. In conclusion from the article, when an individual contracts with an agency to seek restitution, he thus pays the agency to perform two basic entrepreneurial functions. The agency assumes the burden of restitutive risk, and it attempts to minimize or eliminate this risk by coordinating the knowledge of its client, the purported victim, with the knowledge of the third parties, thereby avoiding a clash of violent third-party intervention. The less conflict involved in restitutive action, the greater is the possibility of satisfying the client's desire to be compensated for his loss. Thus, it is in the agency's interest to employ impartial, reliable procedures, and it is in the victim's interest to seek out an agency with precisely this reputation. An agency assumes the burden of future uncertainty, where future information may overturn present knowledge. Again, it is to an agency's interest to employ reliable procedures in order to minimize, to the greatest extent possible, the element of future uncertainty, and it is to the victim's interest to seek out such an agency. Now, is the third party responsible for taking action with partial knowledge? Well, yes. With this, which is why it can't use excessive force. But why should he be held responsible for acting in accordance to his knowledge? Uh, for the same reason why restitutive risk exists. Restitutive risk exists because even though you think you are acting with enough knowledge, you might be wrong. And this is somewhere I disagree with the author, who seems to have given some sort of immunity to the third party. Although similar objections were raised by other people much before me, and I am yet to read the reply that he has written. But like all arbitration process, it will depend on the situation to situation, and different factors will be taken into account. This article then goes on to develop some procedures that the justice agencies can follow which are compatible with the non-aggression principle. Certain guidelines are listed, and these include a public trial unless otherwise requested to have a private trial. Pre-trial violence would be very risky and not advisable. Agency must have public records of its past cases. Agency must open itself to third-party audit and maintain public trust. The agency must provide a defendant with defense counsel of his choice, within an established price range. If the defendant is found innocent, the agency must absorb the cost or pass it on to his client as per the contract. There are of course more listed, and it is an interesting attempt to imply that the elements of the court procedure that we find altruistic can find their way into a free market system due to economic forces. But more than that, I think it was the understanding of justice entrepreneurship which was important, which is why I included this article. So I won't be going into the details of the guidelines. Alright guys, this is all that I had to say about this week's study material. There's a lot more, especially in the myth of the rule of law, and you should definitely read that one. Uh, anything to add? Any questions?
Not me. I think it was a good session. We have already discussed a lot of this stuff, right, in our previous podcast and also in our various other discussion groups. So I don't think there is much to add here.
Yeah, but so I saw these three papers that were, I think, were linked in some way. So
Right.
Hayek Anarchism and the myth of the rule of law, and finally this justice entrepreneurship in a free market. So I thought it would be good to have a discussion from that side of Austrian economics, from the perspective of Hayek, Kurzner, and uh, from the perspective of Hayek, Kurzner, how the free market and law could function.
So what about Shikhar? Does Shikhar have any questions? He normally has a lot of questions.
Anything to add, Shika? Anything that I've missed? Shika?
I don't think he is online. Yep.
His connection is breaking.
So, anyways, if he has any questions, he might send us an email or he might discuss it
Yeah.
offline. So, we're good for the
Okay,
day.
guys. Yeah, I'm stopping. Okay.
Thanks a lot, Shashank, for your
Yeah. You're welcome.
lecture.